The Delaware Riverkeeper Network is opposed to the One Process, One Permit program. We believe the program will undermine DRBC authority. It will undermine the ability of the commissioners to weigh in on water quality impacts and threats. It will undermine the watershed-based approach to decision-making and protection, and it will undermine public participation in project review and the decision-making process. To the extent that the program does advance for the demonstration period, important modifications are critically necessary. The Delaware Riverkeeper Network is submitting significant written comment, but I'm going to highlight a few key points in the time that I have today. Most importantly, because this is a new program with such far-reaching impacts, because it's a program that's intended to be replicated in other states, and that may include at some future point other aspects of DRBC authority, the program needs to include an explicit mechanism for the evaluation of the demonstration's implementation. This evaluation, this review, should evaluate the success of the program at having states fully and fairly apply DRBC regulations and mandates. It should evaluate the effect on the public process. It should evaluate the program's ability to keep commissioners and other states informed and engaged on decisions that impact their watershed resources and states. And it should evaluate the impacts on water quality and on waterway health. Once the evaluation has been completed, it should be provided to the commissioners, to the public, for review and for input. And this entire evaluation review process, including public review and input, needs to be completed before the program is allowed to continue beyond the demonstration period in New Jersey or elsewhere, in order to allow you to decide whether or not the program was in fact a success and you want to continue it, and in order to allow the opportunity to make necessary modifications that have been highlighted by the experience of going through the demonstration. The program needs to be modified to make DRBC the lead agency in a number of key areas, including for all new project proposals that could impact the main stem Delaware River, for all projects that it could impact special protection waters, for any proposals that involve the import of wastewater of over 50,000 gallons from outside of the Delaware River Basin. The need for DRBC to be the lead in these situations is made more pronounced and obvious given the potential for dangerous fracking wastewater, including wastewater contaminated with radioactive materials, to be imported for treatment and disposal in our watershed. And the DRBC needs to be the lead agency on any and all proposals that seek relief from reduction of or modification of DRBC requirements to ensure that the goals of the DRBC and the rights of all watershed beneficiaries are protected. Thank you.
And just referencing Maiv and Rossum's comments earlier, DRN is well aware that there are state administrative agreements and they've existed since the 70s, but DRN is also well aware that in the past these state administrative agreements have been ignored by the states. In fact, there is deposition testimony from high-ranking Pennsylvania Department of Environmental Protection officials, for example, the section chief of the Sewage Facilities Planning and Biosolids section, that they don't comply with those very state administrative agreements. So we have very serious concerns that moving forward, states will comply with those administrative agreements. And secondly, I just want to reference something that was made on the slideshow or presented on the slideshow earlier. I would encourage the Commission in their consideration of this document to take into account the Natural Gas Act and particularly the appeals mechanism that is contained within the Natural Gas Act, which dictates that any initial decision that is made is immediately appealed. The right jurisdiction is immediately appealed to the circuit court that has proper jurisdiction. There is no exhaustion of administrative remedies or anything like that. So I encourage the Commission to take a look at Section 717 RD1 and make sure that they're well aware that that provision exists, because the Pennsylvania Department of Environmental Protection sort of has failed to understand the repercussions of that provision, and there's currently litigation ongoing, and I would encourage the Commission to follow that litigation. That concludes my comments. Thank you.
Aside from everything else, my main concern is if this goes forward, it's going to be very difficult to track any particular project. No, where is that? Where to get this information? When it's going to be open for comment? Where to comment? And I don't understand how that can possibly be done, especially with the information we've been given so far. To say you're going to put a list up, every time a new application comes in, I'm hoping that comes in. I want to know where to go. I don't want to turn up at the last minute and say, I haven't chance to see this thing, but it doesn't look good. And that's all I get a chance to say. And I really have to learn a whole new place to go somewhere in Trenton in a process that I don't know before I get it in order to speak to you on the subject. So I see real problems for people. And I think people have come to really rely on this commission for an outstanding public input process. And we also hate to see any of it go away if it did. So that's my basic concern.
Thank you.